Hello and welcome to the Taxology. I am CA Priyanshu Goyal and this audio episode is part of my podcast series, The Taxology, which aims at imparting information on crucial concepts of the Indian taxation scenario. If you prefer to listen in Hindi, you can watch my videos on YouTube and Instagram. You can find my profile by the name CA Priyanshu Goyal. As with other episodes in this series, this is going to be a very short clip to convey only relevant matters. Before we begin with today's content, I would just like to mention that if you feel like connecting with me, I'm available on Instagram, LinkedIn, and Twitter by the name CA Priyanshu Goyal. In this clip, we are discussing the taxability of the interest income of minor from the inherited estate where the father expired in the accident, and by the order of court, minor would be getting such amount only after attaining majority. So this issue was heard in the case of CB Joy versus Income Tax Officer TDS before the Honorable High Court of Kerala. The elaborated facts of the case are that the person died in an accident, and by the order of court, his wife was entitled to 1/3 of his estate, while his daughter was entitled to 2/3 share from the estate of the deceased. Also, by order of court, daughter's share was to be deposited as a fixed deposit in the State Bank of India until she attains majority. Now, the first petitioner, who is mother, filed an application under Section 197 seeking a certificate for non-deduction of tax with respect to interest income accruing annually on the said fixed deposit, which was rejected by ITO on the ground that the income of the minor has to be clubbed with the income of the mother. Further, the revision petition under Section 264 was made, which was also rejected, and thereafter the appeal was preferred before the Honorable High Court of Kerala. The order passed by the ITO provided that the income of the daughter has to be clubbed with the income of the mother as per Section 64(1)(a) of the Income Tax Act, and that the first petitioner is liable to pay tax for the interest income with respect to the said fixed deposit of the minor. Before the Honorable High Court, it was contended by the petitioner that since the order of the court clearly stipulates that any payment is to be made to the minor only when she attains majority, and any benefit, that is of interest income, arising out of fixed deposit will also be received by the second petitioner only when she attains majority. So, in the absence of receipt of any income in the intervening period, tax cannot be deducted at source, and that also, since there is no income earned by the daughter during her minority, the interest income could not be clubbed with the income of the wife. It was also contended that daughter maintains a cash system of accounting, and therefore clubbing of income under Section 64(1)(a) of the Act in the hands of mother cannot be justified, as no amount or income has actually been received by the petitioners. High Court held that the Income Tax Act does not exempt the interest income accruing to the daughter on an amount received as part of the death benefit of her deceased father, even if by the order of court that income can be utilized only after the minor attains majority. The contention that the income can be taxed only after the minor attains majority cannot be accepted, as the income has accrued on the bank crediting the account of the daughter every year with the amount of interest payable. Further, other contentions raised by the petitioner were also rejected, and the case was decided in the favor of revenue. So it's important to be careful with tax treatment of interest and other incomes being received by the minor, as general perceptions are not the basis for law. So that's all for this clip. I hope you'll find this useful, and if there's any related query or question about this, feel free to reach out to me on info@priyanshugoyal.com.